Good morning. Today is July 27th, and that is an important day for the purposes of our presentation. My name is David Burton. I am the Regional Managing Partner for Williams Mullen and Hampton Roads, and I'm also a labor and employment lawyer. I'm here today to talk to you about how, as a company during this time, you can mitigate your risk. And one of the big risk mitigations for companies will be in Virginia now complying with the Virginia Department of Labor and Industries emergency regulations concerning the return of employees to the workplace and COVID-19. The Virginia Department of Labor and Industry is the first, and Virginia is the first state in the nation to adopt these types of regulations. The regulations go into effect today. They were published in the Richmond Times-Dispatch this morning, and that triggers their ability to be applicable to Virginia employers. What this regulation does is, for a period of 6 months or until final regulations can be adopted, it requires employers to establish requirements for their employees to control, prevent, and mitigate the spread of COVID-19 in the workplace. The way that this emergency standard attempts to do that is by classifying employees and their workplaces into various risk categories based upon the duties performed, the amount of exposure employees may have to the outside world and to other employees, and the type of work that employees perform. Those risk levels are 4. The first is very high. The second is high, the third is medium, and the fourth is lower. By putting employees into their workplace and the employees into these various risk categories, Virginia Department of Labor and Industry's goal and desire is to protect those employees from perhaps contracting COVID-19 and from spreading it to others. Therefore, under these job classifications, there will be various requirements that employers must engage and comply with in order to comply with this Virginia Department of Labor and Industry statute. It is important to note that within a workplace, you may have employees who fit one or more employees or employee groups that fit into one or more of these risk categories. When you start this analysis, however, all employers have a series of requirements and obligations that they must comply with. And those obligations are set forth in the regulation and in some training materials that are being provided by the Department of Labor. The first thing that every employer must do is assess the workplace for hazards and job tasks that can potentially expose employees to COVID-19. Next, you have to inform all of your employees of the methods on how to self-monitor for symptoms of COVID-19 and encourage them to do so. Employers may not use serological testing to make decisions on whether employees who have tested positive for COVID-19 can return to work. The EEOC does not permit that, and so Virginia has said it will not permit it either. Every employer will have to develop and implement policies and procedures for employees to report if and when they experience symptoms consistent with COVID-19 and there has been no alternative diagnosis made. In those circumstances, an employer must designate that employee as someone who is suspected to be infected with COVID-19. If you have an employee who is either known to have COVID-19 or is suspected to have COVID-19, they may not come into work and they may not remain on a work site if those symptoms occur during the day, including any customer sites that they may be working from, until they are cleared to return to work. employers must ensure that they have leave policies in place for their employees who are suspected or confirmed to have COVID-19. To the extent you are complying with the Family First Coronavirus Relief Act, you have those policies in place. To the extent that you have subcontractors or third parties that perform services in your workplace, you must also inform them and make sure that they have policies for their employees who test positive for COVID-19 or are suspected to have COVID-19, and those individuals may not come in to the workplace. You have to create a system to allow employees to report in if they believe, your employees, your contract employees, subcontractors, if they believe they have COVID-19. To the extent that someone has tested positive for COVID-19, then as an employer, you must notify your workforce within 24 hours of the discovery of a positive test. You may not disclose the name of the employee. You are not required to engage in contact tracing, but you are required to notify your employees within 24 hours. You also are required to notify the Virginia Department of Health if you have a positive test in the workplace, and that notification has to occur within 24 hours of learning of the positive test. Finally, on this notification point, if you have 3 or more employees at a site of employment test positive for COVID-19 in a 14-day period, then you must also notify the Virginia Department of Labor and Industry within 24 hours of receiving that 3rd positive test. You have to ensure that employees have access in the workplace to their COVID-19 medical records. You also have to develop and implement return to work policies and procedures for employees who are known or suspected to know that they have COVID-19. Those return to work policies vary depending upon whether you are implementing and using a symptom-based strategy or if you are using a test-based strategy. You also, in your return to work policies and procedures, need to make sure that employees are not returning to work until more than 10 days have passed since they first started receiving the symptoms and they had a positive test. When employees are back in the workplace, no matter whether they have tested positive or not, all employees need to observe social distancing. While on the job and during paid breaks on the employer's property, you have to have policies and procedures to that effect. You need to make sure that your break rooms and any areas in which employees congregate are controlled or closed. To the extent that there are executive orders from the governor that apply specifically to your type of business, you have to comply with those. If 2 or more employees are in a vehicle for work purposes, you need to make sure that those individuals have personal protective equipment. If employees cannot socially distance in the workplace, you have to ensure that respiratory and personal protective measures are taken. And to the extent that you have employees who request that they not wear any PPE, you have to analyze that under the ADA and other applicable standards. You also, finally, all employers have to adhere to the Virginia OSHA standards on cleaning workplaces when there has been a suspected person with COVID-19 there, and just your daily cleaning. Now, as I mentioned earlier, there are various categories that employers fall into. All those requirements that I just went over apply to every employer in Virginia and their workplaces. However, there are different categories of risk, and those categories can add additional requirements. The very high classification requires a lot of what I will call air filtration and requirements such as that. Those types of jobs, though, however, are generally limited to the medical field and industry where individuals will come in, where employees will come into contact with persons who have COVID-19 or are suspected to have COVID-19. If you fall into one of those categories, you will need to understand and know all of the requirements for the very high exposure level. Next is the high exposure level. Again, that will be generally medical fields and things of that nature, although it can get into also some residential care facilities and places like that. The medium exposure level will cover a fair amount of employers in Virginia. It will include people such as poultry and meat and seafood processing places, agricultural and hand labor jobs, transportation services, educational settings, daycare and after-school settings, indoor and outdoor construction settings, restaurants, bars, correctional and juvenile detention facilities, retail stores, call centers, among other types of employers. There are specific factors and requirements that employers must meet if they fall into that medium exposure level. Finally is the lower exposure level. That will be most employers in Virginia. To the extent that you fall into those categories, there are very few additional requirements, and most of those requirements are signage, staggering duties, putting in floor-to-ceiling barriers with people who potentially are forward-facing to the public, such as your receptionists or things of that nature. The last thing that this regulation does that's of importance today is it imposes non-retaliatory prohibitions in the regulation, so that an employer cannot discriminate or retaliate against individuals in the workplace who raise issues concerning COVID-19 or these regulations. There are various categories of prohibited activity, and so it's very important, to the extent that you are in a position where you believe you have to discipline or terminate an employee, that you engage with counsel to make sure that you are taking the appropriate step. These new regulations are going to be difficult in some ways for employers to navigate, but as an employer, you will have to engage in these regulations. You will have to do training, and depending upon the type of training you need to give your employees, those will be postponed. Those requirements are postponed for 30 and 60 days, depending upon the type of training. So that is out there also. To the extent that you need to review this information in more detail, you can go to the Williams-Mullen COVID-19 page, register if you're not already registered, and pull up an article that I did on these regulations last week. It's there for your review. You can also go to the Virginia Department of Labor and Industry website, where they have just put up today some additional tools for employers to use in putting together their COVID-19 return to work plans. Thank you for your time. It was a pleasure speaking with you, and please go to williamsmullen.com for more information on these issues. Thank you and have a great day.